Great. So thank you everyone for joining us today. My name is Dustin Saldarriaga, and I'm an associate at Scott Legal PC. If you're here today, you may already have a non-immigrant investor visa, such as an E2 visa, or you may simply be curious about available paths to a green card that exists through your employer. You are in good company. Our firm was actually founded on a non-immigrant E2 visa 8 years ago. And since that time, we've helped many of our clients who want to permanently remain in the United States navigate the process of securing employment-based green cards. This brings us to our topic of discussion today, which is how to obtain a green card based on employment. A few things before we get started. This webinar is part of a series that we will continue by doing at least 2 webinars a month. These will be on different immigration topics. We already have a number of webinars scheduled and will continue to regularly add more. Also, at the end of this webinar, we will send you a few things. First, we'll send you the PowerPoint from the presentation. Second, we'll send you a link to where you can sign up for the additional webinars. And finally, we'll send you a link to the recording for this webinar, which is being recorded. A few housekeeping items before we get started. We plan to reserve a few minutes at the end of the presentation for questions, but we will also be responding to questions throughout the presentation. If you have a question, you can send it to me through the Q&A function on the app or through the chat box. We have also received several questions in advance, and we'll be answering those as well throughout the presentation. We are lucky to have Kelly Weiner here today to speak. Kelly is the managing attorney at Scott Legal, and she has a vast amount of experience processing both non-immigrant visas and the various green cards that we'll be speaking about today. Kelly, thank you very much for being with us today. I will go ahead and pass it off to you.
All right, thank you, Dustin. So, as Dustin said, we'll be here today speaking about how to obtain a green card based on employment. And we will get started with just talking a little bit about how do you obtain a green card. So on this slide, you can see that there's family-based green cards and there's employment-based green cards. The focus of the presentation today will be on employment-based green cards. But we also wanted to just mention that, we certainly do have clients who are here who pursue green cards through both avenues. Maybe they have a sibling who's a U.S. citizen, or another relative who's a U.S. citizen, or a green card holder, and they're pursuing that, but it's long dated. And in the interim, they're also applying for an employment-based green card. So just to briefly go over the categories, for family-based, there's kind of immediate relatives. So that means there's always a green card category available. So spouses, children under 21, parents of US citizens. And then there's preference categories, which is other categories of, of family members that are potentially eligible based on their relationship to a US citizen or a green card holder. Moving to the employment-based green cards, there's several categories that are listed here. There's the EB1. We're going to be talking about extraordinary ability today. There's 2 other EB1 categories we won't be touching on, but I'll briefly mention them, which is for EB1B for outstanding researchers and professors, and EB1C for multinational managers and executives. There's also the EB2 green card, which is encompasses both the national interest waiver, which we'll talk a little bit more about later, and the PERM, which is where you have a company sponsor you for a green card through employment. The EB3 is also a green card you can get if a company is willing to sponsor you through employment. The EB4 is one of the ones we won't really be touching on, the EB4 and EB5, but just to mention them, the EB4 is for people who are here on R visas, so religious visas that are able to eventually adjust status and get green cards. And similarly, the EB5 is also a green card category where you are, investing, money into the United States, that's either 900,000 or 1.8 million, and are able to get first a conditional green card, and then after proving you meet some additional conditions, you can eventually get a permanent green card through investment.
Great. And Kelly, we did get a question. For someone who's fortunate enough to have the option to pursue either a family-based or an employment-based green card, is there one that's better than the other?
So there isn't one that's better than the other. I'd say they just have different considerations. So For example, one consideration, if you are pursuing an employment-based green card and then you get married to a US citizen, you'd be considered an immediate relative. So that would probably, in that case, family-based might be preferable because there's no wait, and you can immediately apply for the green card process. Whereas with the employment-based green card, if you're in a category that's backlogged or your employer hasn't yet started, let's say you're going through a PERM process, you need to test the labor market, a marriage case may be faster in that case. But let's say you have an employer who's willing to sponsor you and your US citizen sibling wants to also sponsor you. So there's a long backlog, a long wait for that green card category. And so you may want to instead pursue the employment-based green card. And it is possible to pursue both avenues at once. You're not prevented from doing that. But when you're looking at kind of one over the other, you may want to consider, which one is going to get you to where you want to go faster. So that's something to think about when you have both options.
Great, thank you.
Perfect. So let's move on to discuss a little bit more about the employment-based green cards that we're going to focus on today. So one is the EB1 extraordinary ability. So this green card is for people who can show extraordinary ability in the sciences, arts, education, business, or athletics through sustained national or international acclaim. So this is a green card that's appropriate for people that have risen to the very, very top of their field. For example, if you've won a Pulitzer Prize, if you've won an Oscar, an Olympic medal, those types of one-time accomplishments can qualify you for the EB1 if you're coming to the United States to also engage in that area of extraordinary ability. For many people, if they don't have that kind of one-time achievement, the other way they can qualify is showing that they meet three of several criteria. So, as an example, evidence of internationally or nationally recognized prizes or awards, evidence of membership in associations where the demands of members are very high, published material in media about accomplishments that you have, evidence you're asked to judge the work of others, evidence of any kind of major original breakthroughs that you've made in your field of expertise. And there's some others as well. We actually have a separate webinar that dives deeper into extraordinary ability visas generally, but this is the type of visa that you want to potentially investigate if you want to self-petition. So it's one of the ones that you can have a job offer, but you don't have to have a job offer. And it's one that you want to investigate if you are someone who has risen to that very top of your field and you have a lot of evidence to back up how impressive that your accomplishments and achievements are, and you plan to come to the United States and work in that area of extraordinary ability. So it's not for people who have achieved a great amount of success and want to now retire. It is for people that plan to bring those skills to the United States and continue to work in that area of extraordinary ability. All right, so let's move to the EB2 national interest waiver. So this category is for people who can show they have an advanced degree, so a master's degree or higher, or the equivalent, or who can demonstrate exceptional ability in their area of expertise. And the extra part of this, the national interest waiver part, is where you submit additional evidence to show that you merit a waiver of the normal job offer and labor certification requirement, because it would be in the national interest of the US. And to get, to prove that you can, that the waiver is justified, you have to show that you're working in an area of substantial merit and national importance. You have to show that you have the ability to advance, your proposed endeavor, and that on balance, it would be beneficial to the US to waive the requirement of the job offer and the labor certification. So to give you an example, this category, the standards for it changed relatively recently within the past, 4 years. And, one reason that it could be beneficial to waive the job offer is if you're an entrepreneur. So the PERM labor certification process that we'll talk about more is not set up for entrepreneurs. If you own a company 100%, you're not going to be able to be sponsored by that company because that's the way the system is set up. So for that reason, entrepreneurs sometimes can, take advantage of this EB2 national interest waiver if they are, if their company is really focused on job creation, that's definitely something that's in the national interest. If they're developing a specialized, product that's having a really positive impact on even a local economy, and if they themselves can show an impressive track record, and they also need to meet this metric of a master's degree or higher or exceptional ability, in the, to get to that EB2. So the another EB2 category, we'll talk about EB2 and EB3. These are grouped together, under PERM/company sponsorship. So this is a category that's very frequently used. People, will often read about the process of you come to the US on a temporary visa, and then you are sponsored by a company and to get a green card. And so this process is a full-time job offer is required from the company. And the company has to test the labor market to determine if there are any willing, qualified, and available US workers who can hold the job, that either you're currently holding or that they plan for you to hold in the future. And when we say test the labor market, they actually do have to place advertisements, they have to interview applicants, and they have to keep very detailed data that shows, why it is that the people they interviewed actually were not qualified for the job. If they go through that whole process and no, willing, qualified, and available US workers are found, then they can submit what's called a labor certification to the Department of Labor. The Department of Labor will review all of the information. They can audit the application, meaning they can ask to see documents. They can make their own assessments of were the people who interviewed for the job actually qualified. And then if they approve it, they certify the labor certification. And then the company can proceed with filing what's called a Form I-140, where they are saying we want to sponsor this person for this job. And then the applicant, if a visa is available to them, can file a green card petition, either through adjustment of status in the United States or through consular processing at a consulate abroad. When you do the I-140 part of the application, that's also where the company has to show they have the ability to pay the prevailing wage. So companies have to basically agree that they're going to pay a certain wage, and that's set by the Department of Labor based on the type of job. And additionally, the applicant has to show they meet all the requirements. So if the employer tested the labor market and said this job requires a bachelor's plus 5 years of experience, the applicant needs to show they have that bachelor's, they have that 5 years of experience, and that they had that experience before they joined the employer. And so then finally, and we won't go into this in too much detail, but there is the EB5. So that's the investment green card, where you are investing either $900,000 or $1.8 million, and showing that you're going to create 10 new full-time jobs. The way that it works is you submit an initial application called an I-526, proving where the money's come from and that you've made the investment. Then you can, once that's approved, you can apply for the green card. Once you get the green card, it's a conditional 2-year green card. And then after the 2 years, you can apply to remove the conditions on your green card by showing you've sustained your investment and created those 10 full-time jobs.
Perfect. Thank you, Kelly. And I did want to quickly note that we have a separate webinar that is specifically on the EB5 for individuals who are on an E2 visa. That goes into great detail on the EB5. We have a few questions on the information you just covered, Kelly. First, if you could, you mentioned the concept of self-petitioning. If you could take a step back and share which green card categories allow for self-petitioning and which require a job offer.
Sure, absolutely. So self-petitioning, is you have the benefit of, you can submit the application yourself. You're not reliant on a U.S. company or a U.S. sponsor to, to file a petition for you. And the categories that allow for this are the EB1A extraordinary ability and the national interest waiver EB2. So in those situations, you can petition for yourself. However, in the other circumstances, so an EB2, where they're going to do a PERM, and similarly an EB3 where they're going to do a PERM, you need a job offer from an employer. You're not able to just petition for yourself.
Perfect. And then is there a specific requirement in terms of the non-immigrant visa that someone must be on before they apply for an employment-based green card?
There's not. So the PERM it's very common for people to come to the United States on what's called, an O1, known as the extraordinary ability temporary visa. And then potentially those people, because the standards, the requirements and the regulations are somewhat similar, it's very common for then those people to maybe transition to an EB1 if they can meet that elevated green card standard. Similarly, people often will come to the US on an H-1B and then have their company sponsor them through the EB2 or EB3 process. But there's no requirement that you hold any of those temporary visas before you get a green card. In fact, you can be entirely outside the United States the entire time, and have a company sponsor you, or you can submit an application for yourself. So although there is often a track people follow, just because it, will not kind of naturally lead into, you have an H-1B, you're working for a company, they may be willing to sponsor you. It's not a requirement.
Great, thank you.
All right. All right, so let's talk a little bit more about the labor certification process and what a PERM entails. So we have the EB2 and the EB3. These are kind of the main, PERM categories. And PERM refers to the process where a company is sponsoring an applicant for a green card. The company has to test the labor market. And the way that they do this is it's kind of a multi-step process. So first, the company has to design a job description that only asks for the minimum requirements to do the job in a reasonable manner. So for most employers, when they're putting a job out there, they're saying, I want excellent communication skills, and they're kind of asking for the maximum. But what the PERM requires an employer to do is to step back and say, okay, like what's the minimum that that somebody could do to get this job done? Because they want, through the PERM process, to make the process as open as possible to US workers. So once the company has designed their job description, they'll submit a prevailing wage determination to the Department of Labor, and the Department of Labor will look at those job descriptions, look at those requirements, look at the proposed occupational code, and they'll say, okay, based on data that we have about average wages in the US, this is what you need to pay. So then the next step is, if the company's is fine with that, it's fine with that wage, then they'll actually go ahead and they will place ads. And so there's a regulatory requirement for how many ads they have to place and where they have to place those ads. And there's also a requirement for how long that recruitment process has to go on. So it has to be a process of at least 60 days where ads are running, generally for the first 30 days. And then for the second 30 days, the ads might be down, but the company still has to interview any workers that are coming. If no willing, qualified, and available US workers are found, then that's when the company is allowed to go ahead and submit that labor certification to the Department of Labor. As mentioned, they may audit it. So the PERM system, basically the form you submit says, here's all the things that we did. We posted ads, we didn't find anyone. But the company is also going to be keeping records of the advertisements and the people they've interviewed. And the Department of Labor sometimes wants to see proof of who applied and how the company interviewed them. And there's additionally some kind of audit triggers. So for example, if a job requires a foreign language, that's very often a trigger for the Department of Labor to want to see more information. Additionally, if it's a job that the Department of Labor thinks should only ask for a bachelor's plus 2 years of experience, and the employer is asking for a master's plus 10 years of experience, then that's something as well where they may want to see additional documents to say, well, why is it that this job is so elevated that it has such a high standard for the requirements that's really outside the norm of what we think is appropriate. So once the Department of Labor has approved the labor certification, if they go through it and they think it's fine, then you move on to steps 2 and 3 of the PERM process. So step 2 is the I-140, and that's a petition where the company is going to say, yes, we want to sponsor this person for this job. Here's what the job is. It should match with what was on the labor certification. The I-140, with that application, you'll have to submit the labor certification. You'll have to submit tax returns and financial records of the company showing they have the ability to pay the prevailing wage once the green card is granted. And you'll also have to submit proof that the applicant meets all the requirements. So often this takes the form of, degrees, if it's a degree is required, and then additionally employer letters. So the applicant has to be able to provide proof that, if 5 years of experience with a particular computer program was required. They have an employer letter, a detailed employer letter that explains, yes, this person worked for this company for 5 years. During that time, they worked on this computer program. So if you can't provide that at the I-140 stage, the petition can't move forward. So usually you're going to kind of work with your attorney at the beginning of the process, even before you do the PERM, to make sure the company has the ability to pay and to make sure that you as the applicant are going to be able to meet all those requirements that are listed in the labor certification. And then the third step is, is the green card step. So that's where if a visa is available to you, if the category is not backlogged, then you're filing what's called an I-485 if you're inside the United States, or if you're outside the United States for some reason, you can file for the green card through consular processing. A couple things to talk about with the I-485. So we have, on the slide, something that says, current versus not current. So particularly for kind of Indian and Chinese nationals, there is a backlog in many of the, in the EB2 and EB3 categories, meaning that you might get through the first 2 steps. So you get through the labor certification, your I-140 is approved, you have your priority date, which is the date that the PERM was filed, but you're not yet able to file the green card. And that's because there's just a backlog in the number of green cards that are available. So if that's the situation, then sometimes there's things you can do. For example, if you're on an H-1B, then there's an exception that allows you to continue extending your H-1B. If you're on another type of green card that where you can continue to extend it. I'm sorry, not green card, a temporary visa where you can continue to extend it. That's something you can look at as well. But if you are in that situation where your priority date's not current and you can't immediately file for the green card, if you want to stay in the US, you will need to consider, how do I maintain some type of underlying status? And is that status going to, am I going to be allowed to stay here if I have a green card application, pending?
Perfect. And Kelly, we did get a few questions. One very important one. How long does the PERM process generally take?
So the PERM process, it varies because of the timelines that are set by different bureaucratic systems. So for example, the Department of Labor, in the time that I've been doing PERMs, at sometimes it takes them 2 months to issue a prevailing wage determination. Right now it's taking about 7 months. Similarly, the actual adjudication of the labor certification, sometimes Department of Labor is taking 2 to 3 months to adjudicate it. Right now, again, they're taking about 7 to 8 months. So the timeline can vary significantly, but generally, I'd say you are looking at a process that's maybe 1 to 2 years, before you actually have your green card physically in your hand. And part of the reason that it does take so long is that there's these delays at the Department of Labor, but even if those delays were shorter, USCIS, U.S. Citizenship and Immigration Services, also has delays on how long they're taking to issue green cards. So once you filed your I-485, if you're in the United States, it's going to go to a field office, and a field office may have a processing time of 9 months for employment-based green cards, but more, especially with COVID and kind of additional backlogs, some of them are quoting between 9 months and 36 months. So that's quite a long period of time. So, I'd say generally about 1 to 2 years before you physically have your green card in hand. So it is a good idea to get started with your employer sooner rather than later if you can, but you just do have to keep in mind in terms of managing your expectations that the timelines may change. They may get better, but they also may get worse, just depending on, what is the situation at the various U.S. agencies that process these applications.
Perfect. And since we're on the topic of timeline, we have received, it seems like there's a lot of interest in the EB2 NIW, National Interest Waiver. So there's a question about what the average processing time is for someone who's outside the US for the I-485 through consular processing for current status countries. Do you have any insights on that timeline?
Yeah, so I'd say that for the EB2 NIW, you don't have to do the PERM. So you're skipping that whole kind of, first of the 3 steps we've been talking about. What you file is the I-140. If you're doing a PERM, then when you file the I-140, you can use premium processing where you can get an answer within 15 calendar days if you pay more. The NIW unfortunately doesn't have that option. So let's say that you're filing an I-140 in the United States, you're not here. Processing times for those right now are running between 9 months to about 16 months. So you can't apply for the green card through consular processing until you get that initial approval on your I-140. If your I-140 is approved after that time frame, then it's going to go to the consulate. And we'll talk a little bit more about consular processing and that exact process later. Unfortunately, it's not possible to give a timeline. It used to be that it would take less time to get a green card potentially through consular processing, than through USCIS. However, the impact of the pandemic is such that really consular processing across the world has slowed significantly. And what they're doing now is trying to get through a backlog of, hundreds of thousands of cases for family-based immigrant visas, and about, I think it's about 11 to 12,000 employment-based cases. So that's to say that it's specific to the consulate that you're at. Some consulates are getting back on their feet faster than others, but it's right now, I'd say you're looking at an extended process, several months to even perhaps, longer, a year, just because of where we are with consular processing, where consulates are each on their own starting to revisit both temporary and permanent visa processing after shutting down completely last year, in March, starting to reopen in July, going back and forth. So it really does depend on kind of what's the situation with COVID in a particular country, and also the staffing at that consulate. So it's a very kind of consulate specific question, unfortunately.
Great. And then the final question on this slide, and I think it's in the back of many people's minds: what if the employer finds a qualified U.S. worker in this process?
Sure. So if you do find a qualified U.S. worker, then unfortunately the process does have to stop. So the purpose of the PERM is to say, let's test the U.S. labor market. Are there any U.S. workers that can do this job? If you do find a U.S. worker, the company can't proceed with the PERM. They don't have to hire the U.S. worker. That's something that, kind of often employers will ask that question. So it's certainly not required to kind of hire anybody that you find, but you do have to stop the PERM process. What you can do is you can test the labor market at a later time. So what that means is if the person's working for you on an H-1B, let's say they have 3 years left, you test the labor market, you find a qualified worker, so you stop, and then 6 months later, perhaps you try again. So, kind of finding someone doesn't mean that the PERM is completely dead, but it does mean that iteration of the advertisement cycle, you're not able to proceed at that time.
Great, thank you.
All right. All right, so let's talk about kind of the adjustment of status versus consular processing. So, an adjustment of status is where you are going to file an I-485 with U.S. Citizenship and Immigration Services from within the United States. You are able to remain in the U.S. Once you file this petition. In fact, you have to remain. Otherwise, you'll potentially be considered to have abandoned your petition. When you file this I-485, you also have the ability to file what's called Form I-131, which is travel authorization, and Form I-765, which is work authorization. So for as long as you're in the United States, with this I-485 pending, you can continue to renew those. So usually the work and travel authorization are granted in 1-year increments. It used to be that was sufficient because the green cards were being granted before then, and that's still possible. But given the extended timelines at many field offices for granting green cards, sometimes we're finding that you are having to renew it. But the benefit is that you can continue to renew it up until you physically have your green card in hand. So it does kind of give you that ability to stay in the U.S. and to continue to work and travel while you wait for your green card to be adjudicated. And then at the end of the process, most applicants will have an interview with the USCIS officer. This is a relatively new development that was kind of put into place during the previous administration. Prior to this, employment-based applicants really were not interviewed. It was very, very common that the interview was waived and they kind of just went ahead and got, their green cards were mailed to them, the case was approved. As it is now, officers, that discretion to waive the interview has been greatly curtailed, and officers now are needing to interview most employment-based applicants. So you just want to be prepared, that you likely will have to have an interview with the USCIS officer. It's not always the case, especially during COVID. We've noticed that every now and then they're being approved without interview, but that is part of the process. Moving to consular processing. So what will happen with consular processing is you file your I-140, that has to be approved first. And then the approval is going to be sent to something called the National Visa Center. So once the National Visa Center has the approval, they'll send an email to the applicant and the attorney. The applicant will then need to fill out a form called the DS-260, which has a lot of biographical information. So a lot of the same information that's on Form I-485 is going to be on the DS-260 if you're processing outside the United States. You're also going to be asked to provide supporting documents, so birth and marriage certificates, any proof of if you have a police record. Similarly, if you've lived in any other countries, you have to provide police records from those countries. So you'll send all those documents to the National Visa Center. Once they review them, they may come back and say, hey, we have some questions, we want more documents. Or they may say, great, we have everything we need. We're going to go ahead and send this to the consulate. So that, in normal times, I would say once they've, had all the documents, they'd schedule the interview within about 30 to 60 days. Unfortunately, that timeline no longer applies because of COVID-19. We are hopeful that as the vaccine rollout continues, things will start to normalize, but a backlog is going to have to be gotten through first. Basically at this point, what we're seeing is National Visa Center is confirming, yes, we have all your documents. We'll let you know once the consulate is scheduling, and they check in with you. They'll check in with you at 60 days. They'll check in with you at 120 days. But it is just taking longer. Additionally, once you have your consulate appointment, you'll need to do a medical exam, and then you will attend an interview at the consulate. So that's always the case with consular processing. It's never the case that you would be granted the green card or approved for the immigrant visa without an interview. You will always need to go to an interview. If they approve it, they will give you, a packet of information. You'll take that with you when you enter the United States. You'll get an immigrant visa in your passport that you'll use to enter. And then once you've entered, your green card will be mailed to you within 30 to 60 days after entry.
Perfect. Thanks, Kelly. We do have a couple questions. If someone has the option of applying for a green card through adjustment of status within the U.S. or through a consulate, do you have general guidance you give them in terms of making that decision as to which is preferable?
So I think that similar to kind of which green card to choose, family-based or employment, I think it always depends on their specific situation. So if somebody is primarily living in the United States, generally adjusting status through the I-485, form and process is going to be the way to go. The benefit is you can remain in the United States, you can continue to extend that work and travel authorization. If your family is with you in the United States, they'll also submit their I-485s with you. They can also apply for work and travel authorization. I'd say what used to be the kind of con of I-485 versus consular processing is that it was taking longer to get the green card from within the US. That's really no longer the case because of the backlogs in consular processing. So if somebody's kind of main home is the United States while they've been working, they've been here for several years, I'd say that usually the adjustment of status is going to be the way to go. For some families, if your family is really mobile, they need to travel a lot while the adjustment of status is pending. And particularly if they aren't on H or L status, which does allow you to travel freely, or let's say it's someone that you don't reside in the US yet, you've been coming back and forth, you have an employer, but really primarily your residence is outside the US for right now, that might be a case where consular processing is going to be better, going to be a better situation for you. Because if you file the adjustment within the United States, you do have to, and you're not on H and L status, you do have to wait until you get your travel authorization to travel. Otherwise, your green card application is going to be abandoned. So for some people, it doesn't work for them, doesn't work for their life to be in the US, file an adjustment of status, and have to wait for 6, 7, 8 months for that travel authorization. So in that case, consular processing might be a better way to go.
Perfect. And then obviously this is not a family-based green card webinar, but obviously family is a very important piece of employment-based green card. So if you could quickly touch on, if someone is granted an employment-based green card, what does it look like for that person to bring their family members? And this person is specifically asking about their sons, who I believe are under 18.
So, if they're not in the United States, you mean?
Yes, I believe that's right.
Yeah. So, I mean, I'd say generally the way that it works is, if you were getting a green card in the United States, you would file your petition. There's something called follow to join benefits, which is basically where people, either you can do one of two things. So one is that if your children are able to get dependent visas, like if you're here on an H-1B, they're outside the US, they're under 18, but you can get them H-4 visas so they can enter the US and then file the petition. That's probably with you. That's probably the most straightforward way to go. I think that's, then you're kind of all there together. You can also do something called follow to join, which I won't go into a ton of detail here, but it's essentially just, if you're getting the green card, yes, there is an ability for your dependents to get the green card through a consulate from outside the United States, but it just might take a bit longer. And it's going to be, obviously a more disconnected process where you have to deal with two agencies. So if you do have the ability, if you're here on a temporary visa, your children under 18 should have the ability to get dependent visas and enter the US. And the kind of most straightforward way to do it is going to be to have them enter and then adjust with you in the United States.
Perfect, thank you. And one question, and this might be a bit granular, but on the green card application, you need to list prior places where you've lived. And the question is whether there's a certain period of time that qualifies, like you need to have lived in a place for a year, or does that exist?
To allow you to file the green card application?
Yeah, when you list and the government does its background check, so to speak, on reviewing your past addresses, do you generally recommend that all addresses be listed, or is there a certain period of time that you say if you've lived in a place less than a certain period of time, you don't need to list that address?
So, I mean, I think, generally the forms will say like, or for the green card application, they're going to say like for the past 5 years, where have you lived? You should list every address, that you've ever lived at. So even if like, sometimes people will kind of, especially if they're in college or something like that, like they might live in a dorm and then they go back to their parents' house and they go to another dorm. We always recommend including a full history that includes the time spent in the dorm, the time spent in the parents' house, and back and forth. So you do want to provide that information, as much as possible, explaining, where you've lived. You want to answer the questions as honestly as you can. You don't really want to skip anything. And you can always, usually there's space on the forms. You can always kind of provide explanation. If the explanation was, I was traveling for 6 months and I stayed in a bunch of hostels. You want to kind of provide as much as you can and then explain for anything where you don't have those dates, where you don't have those addresses.
Perfect. Thank you.
Perfect. All right. All right, so let's talk about kind of who can pay. All right, so, this comes up a lot. People want to know, both employers and employees want to know kind of who has to pay for this process, especially because it can be an extended process. Sometimes, there can be significant fees. So for fees related to the PERM process, that first step, any legal fees, kind of other fees. So for example, you have to post in a newspaper, there's going to be fees associated with that. You have to post in a professional organization, there's going to be fees associated with that. All of that has to be paid by the sponsoring employer. They cannot receive any payment, from the employee. They cannot require the employee to reimburse them. And there's actually even a question on the labor certification that says, has the employer received any payment for this? So, it's a very clear rule. The employer has to pay. The employee cannot pay. The fees for the I-140 petition, the green card petition, and dependents, and the accompanying USCIS fees, all of those can be paid by the employer or the employee. So let's say you have an agreement, with your employer, they may want you to pay that. They may not be willing to pay that, but certainly for that first part, the PERM process, they are required to pay for those fees.
Perfect. And Kelly, a quick question. If someone leaves their employer while the process is pending, this is made clear, I think, through what you've said, but just to clarify and emphasize this, the employee leaves the green card process while it's pending. Can the employer require them to repay the fees?
So I'd say they can't for the PERM fees. However, if they, let's say you had an agreement that they were going to pay for the PERM fees and for your dependents and for the I-140 and the I-485, there may be some ability that they have to ask you, like if you've signed something that says that you'll reimburse them for those other fees, there's nothing that prevents them from getting reimbursement for those other fees. So the PERM fees, no, there's no ability, but if they paid for other fees, yes, there is some ability for them to potentially require reimbursement.
Thank you.
All right. So now let's talk about dual intent. Dual intent is the concept that you can be in the US on a temporary visa, for example, like an H-1B, and it's still permitted that you can apply for a permanent visa, a green card. There are some single intent visas, for example, a TN or an F1 student visa, and these are temporary visas that have single intent, meaning that when you apply for these visas, you have to demonstrate that you don't intend to move to the US permanently. And for some of them, you even have to go a step further and show you actually have a residence abroad that you don't intend to abandon. Some of them, like the E2, you don't have to show a foreign residence, but you do have to show that you don't intend to move to the US permanently. So the benefit of these dual intent visas is that you can be here on that temporary visa while still openly applying for your green card and have it not be an issue. The dual intent visas, the H-1B and the L, it's very clear. Recently, USCIS has, and the regulations have kind of altered a little bit to make it even clearer that the O visa can also be considered, pretty much a dual intent visa. That's a benefit for all these visas, that if you are here in the United States and you are applying for a green card, and you don't have to worry about timing when you submit that application. You don't have to worry for the H&L about any travel. Once you submit it, you're still allowed to travel on the H&L visas. If you want to, if you have your green card application pending, but you still want to renew these underlying dual intent visas, you can do that without issues. So that's the benefit of dual intent.
Great. And Kelly, there was a question about timing regarding dual intent. So this person is starting on an H-1B visa in a professor job soon, and they ask how long they should wait before starting the green card process. Do you have thoughts on whether there needs to be a lag time before someone submits that green card application?
For an H-1B?
This one is for an H-1B, yes.
So for an H-1B, no, you do not have to worry about it. You are fully allowed to apply for the green card. There is no issue at all. You don't have to worry about lag time. If you want to come here on the H-1B and then immediately submit a green card application, you can certainly do that. There's no issue there. The issue that might arise is if you're here on a visa that doesn't permit dual intent. So let's say you were on a TN visa, or you are on an E2 investor visa. So those are visas that don't allow for dual intent, which means that when you get those visas, you have to convince the officer that you don't intend to move here permanently. Something to remember about intent is that it can change over time. So let's say you enter on your TN, you get it for 3 years. Your intent may be temporary, when you enter, but you over time might be having conversations with your employer. Like let's say a year down the line, they say, hey, we really like your work. We'd love to sponsor you for a green card. There's no issue with that. So you can certainly go ahead and do the green card process. What you do have to remember is that you would not be able to travel freely on the TN once certain parts of that application are filed. So if you are on a TN and your employer has filed an I-140 immigrant petition for you, traveling, might be a little bit more tricky, because now they're going to say, well, you say that you have a temporary intent, but your employer is filing an immigrant petition for you. So that by itself isn't usually enough to stop you from entering, but it would mean that probably you couldn't renew your TN because the officer likely wouldn't believe that you had temporary intent. And at that point, you really don't. So you need to kind of weigh that. So let's say that in Dustin, in your first example, let's say that the person was on a TN and not an H-1B. I would say there's definitely a problem with entering and immediately filing for a green card. In that case, you've entered, you've said your intent is temporary. You really need to wait at least a few months, if not more, before submitting that green card application.
Perfect. Thank you.
All right. So let's talk about the considerations when moving from a visa to a green card. You want to kind of think about how much time is left on your underlying visa. As we kind of just mentioned, some visas are hard to extend once an I-140 petition is filed or a green card petition is filed. So, if you're on an H-1B, no problem at all. You can pretty much extend. Even if you're on an O, you can extend. Once you're on a TN, if an I-140 petition is filed and you've indicated you're going to adjust status in the United States, that's pretty much the end of the line for the TN. You're not going to be able to extend. At that point, you'd need, if you wanted to stay in the US, you would need to kind of go ahead with filing your green card petition and, stay in the US on the basis of that pending green card petition. With the H-1B, usually you have 6 years. So you do want to think about kind of how much time do I have left? If you're in one of those backlogged categories, then you may be able to get further extensions. But you want to be thinking to yourself, am I going to run out of my H-1B time before I'm able to file my adjustment of status in the United States? So you just want to be thinking and planning with your employer and your attorney to say, am I on a visa that can be renewed indefinitely? Am I on a visa that's time restricted? If I am, what's our timeline for getting this PERM approved based on the current USCIS and Department of Labor timelines? And what's our plan? If what your goal is to stay in the United States for this entire green card process. Another question you want to ask is, do I want to adjust status in the US or do I want to get the green card through consular processing? So that's going back to those considerations we talked about earlier. Is your life in the US? Do you want to stay in the US? Is that kind of your main goal? Do you need to be able to travel a lot? Are you not, if you do and you're not on H-1B or L status, that's something to consider. Can you actually stay in the United States for the 6 to 8 months it's going to take to get your travel authorization? If that's really not feasible for you or your family for some reason, then maybe consular processing is the way to go. Similarly, if you've just looked at your underlying visa status, maybe your employer, you changed employers a lot, maybe your employer didn't want to, extend your status, or maybe your employer didn't want to sponsor you. Now you're on your last year of H-1B. There may not be time, to kind of qualify for one of the extensions. So you just want to kind of think about all these things, when moving to a green card. And certainly with your employer, if you are hoping to be sponsored, you want to raise that question earlier rather than later to see, here's how much time I have left on my H-1B. What's the company's policy about sponsoring? Another thing to consider is, your children. So do you want your children to adjust status with you? If you do, then you want to maybe consider filing earlier rather than later to avoid issues with children aging out at 21. So this is something we also talked about in our national interest waiver webinar. I know there's a lot of national interest waiver questions, and I do just want to say we also have a separate webinar on that that is recorded, is available on our website, that goes over a lot of the transition, particularly E2 to NIW transition in a lot more detail. So I definitely recommend checking that out. But for E2 investors, you can renew that indefinitely. But if you're here and your company is doing well, you think you qualify for an NIW and you have children, you may really want to think about maybe filing earlier rather than later so that they're not aging out at 21, because once they're at that age, they're not going to be able to be part of your application. All right. So let's talk about the green card interview considerations. So as I said, it used to be the case for USCIS that most employment-based applicants did not have to attend green card interviews. That is no longer the case, unfortunately. Now they generally do have to attend interviews. big things that kind of come up before those interviews, you want to make sure that the job is the same that was offered in the PERM, especially if there's kind of a long runway. If we're talking a couple of years, things change over time. You want to make sure that, it's the same location, the job wasn't transferred, Texas to Florida, or that if it was, you've spoken with your attorney, so you understand, kind of what the constraints are going to be. The job duties should be the same. If someone's been promoted to a completely different job, that often is going to be an issue for the, for the green card application. If you've had an average yearly raise, that's not a problem. But if kind of if the salary has gone below the prevailing wage, that's okay as well, as long as the employer can attest that they are going to pay the prevailing wage once you get the green card. So, when you're looking at green card considerations, you want to, before you attend, review your petitions, review your I-140, review the labor certification and the green card petition, the I-485. You want to organize and print the documents and bring them with you to the interview. So we recommend kind of bringing a binder, with all of your documents in it. USCIS will often have, copies of everything, but they'll want to see originals of certain documents. So original birth certificates, original marriage certificates. You'll have to have a medical exam done. So if you're applying abroad, that's going to be sent directly to the consulate from the medical provider. But if you're in the United States, either you'll bring the sealed medical exam with you. You might have mailed it in earlier. You'll need updated proof of employment from your sponsoring employer if you work for them. So if you're in the US, working on the H-1B, they're going to want to see a job offer letter that reflects, the job that is the PERM job that says, yes, we employ this person. Here's their job duties. Here's what they make. And that should reflect what's in the PERM. If you're in the US, you also have to prove that you've maintained your status through every entry that you've ever had to the United States. So if you've ever had any issues with maintaining status, even if you fell out of status for just a few days, that's something that's going to have to be disclosed on the I-485. There are workarounds. So there's something called 245K, which is specific to employment-based applicants, that allows you basically to leave and re-enter the US, and they'll forgive a lot of old status violations. But if you're making that argument, you want to make sure that you've cleared that with your attorney, that it's very clear in your mind how to explain it to the officer. And if you've never had any issues, then that's great, but you still need to bring proof. Like, let's say you started in the US as a student and you've been here for 10 years, you need to bring proof you've maintained your status the whole time. Another good thing to do is you want to meet with your attorney and you want to do a practice interview. Even if you don't realize it can be a nerve-wracking situation, and you want to make sure that officers are looking for all different types of things to assess, is there fraud, are people misrepresenting anything? Many officers are very reasonable, but some are not. And so you want to just make sure that when you're going in, you're really confident in the material, you're really confident in the things that have been represented to them. They'll ask questions both about your job. So, they may ask for your job offer letter, your pay stubs, but they're also going to ask questions about the green card application. So they may run through a bunch of the security questions to confirm, have you ever been arrested? Have you ever had status violations? One thing they like to ask a lot that's on the form is, do you plan to practice polygamy in the US? You want to make sure all your answers reflect no, no, no. Or if you haven't had any status violations, that you're able to explain those things. One other thing to consider is that if you have dependents with you, you may also want to bring proof of the validity of the marriage. So because employment-based interviews are somewhat new, officers sometimes will fixate on, well, has your spouse just married you to try to get access to the green card? So you do also, you're not preparing a marriage-based application, but you do want to bring proof. So if you have children, you're bringing their birth certificates anyway. If you have a joint mortgage, you bring proof of that. Photos of you guys together, joint bank statements, joint financials. It's always a good idea to have those things for your spouse as part of the application, because they will be coming with you to the interview.
Great. Kelly, you touched on several of the questions we received on this slide, but we did get one about the slide, the earlier slide, the slide just before. The question is asking whether you can clarify regarding children who may age out, who may reach the age of 21, is the relevant date the filing date or the visa approval date? What should people keep in mind if their children are approaching that 21 year mark?
Sure. So it used to be the visa approval date, but there was kind of changes to the law that basically recognized that children were aging out, and so there's something called the Child Status Protection Act. So basically, what you need to it's basically going to be the date that you file the application. Like if you're filing let's say that your I-140 is filed, and your child is, 20 years old in 6 months, and it takes 6 months for the I-140 to be approved, and now they're 21. That's okay. The Child Status Protection Act allows you to subtract the 6 months that the I-140 was pending, and then once you can file the visa petition, they're under 21. So it's really going to be the date that you're filing the visa petition. I mean the I-485 application. So, but it is I'd say it's a complicated area that does require the calculation, but it's not the visa approval date, like the green card approval date anymore. So that is a benefit that children will get, so that they're not aging out while they're waiting for these long, long processing times.
Great, great, thank you.
All right. So let's talk a little bit about porting. So especially because it's taking so long for people to get green cards, situations change, life situations change, jobs change, and so a common question is kind of, can you change employers during the green card process? And the answer is sometimes. If you're in a situation where your I-485 has been pending for at least 180 days, and your I-140 that's connected to this 485 is approvable, then yes, you can do something called porting. It's a great benefit to the new employer. They don't have to complete a new PERM. They don't have to complete a new I-140, but you do have to prove that the I-485 has been pending for at least 180 days. And you have to prove that the new employment is in the same or similar occupational classification as the job in the I-140. So you can't kind of completely pivot, you can't go to a completely new, kind of type of job. But if you're getting offered, a job in very, same or similar occupation to the job you're already holding, then yes, you can change to a new employer while you're waiting for this long dated green card to, to pen. So it's a very specific point in time though. So, there may be, sometimes people have a PERM process ongoing for them and they want to change employers. If they're on an H-1B and they have that porting ability, or they're on another type of visa, yes, certainly you can do it. But just the fact that another employer has had a PERM pending for you doesn't really mean anything. Your new employer is going to have to start all over. Similarly, even if you've gotten to the I-140 approval stage, that's great. You have an I-140 approval. For H-1B, often it means you can extend your H-1B, but your new employer is still going to have to file a PERM. So the benefit of kind of porting at this stage of the process, where the I-485 is already filed and pending, is that none of that has to be done. The new employer can kind of just step in, file a new form, and kind of you can then proceed as long as you can show the job is in the same or similar occupation.
Perfect. And Kelly, I think we are ready to turn to questions and answers, unless there was anything else you wanted to cover.
Let's see. So the only other thing I wanted to cover is, in terms of, can I change my employer after I get my green card? When you obtain an employment-based green card, you are making a good faith attestation that you intend to work for this company. So, you want to keep that in mind. Like if you get the green card with one company and the next day you quit and you go to another company, that's something that is technically allowed. No one's necessarily going to stop you, but if you want to naturalize down the line and become a US citizen, they're going to look at your history and they might think that, well, you made a good faith attestation on Tuesday, and on Wednesday you changed employers. So that's not gonna read very well, and if they find if they find fraud, they find misrepresentation, that's going to be an issue. So yes, it is possible to change employers after you get your green card, but you want to keep in mind that when you're submitting this green card application, you are making a good faith attestation. You're going to continue working for that green card company. Let's say they fire you the next day. There's no problem with that. Like you're not, that wasn't on you. You can find another employer. But it's just something you want to keep in mind, is that, you don't want to switch jobs right away or too quickly, because that is something that can come back later and be an issue.
Great. And Kelly, actually, we do have a few questions on the topic of porting. If someone makes a request to port to a new job and USCIS denies the request, can that person go back to their old job?
So unfortunately, no. I mean, they can go back to that old job if they have an underlying, like H-1B, let's say, and their old job is willing to take them back, then yes. But in terms of, can they just say, okay, well, let's rescind this porting request and just process my green card application as though I was working for the old employer? Unfortunately, that's not possible. When you submit your porting request, it's a I-4 called an I-485 form supplement J, and you're going to be submitting it to the to USCIS and saying, this is my new job offer. Please adjudicate this I-485 with this new job offer. And so if they reject it for some reason, that I-485 is going to be denied. And if you wanted to proceed with a green card application with your old employer, they would have to kind of restart that process. If they have an approved I-140, it may just be kind of filing a new green card petition, but you can't kind of say, okay, well, you rejected the porting request, let me just go back to the first job.
Perfect. Thank you. And so we actually are bumping up against our deadline here, the end of the hour, and fortunately have made it through, I believe, all of the questions we've received, which is great. Kelly, I want to thank you again for taking the time to speak with us today. This has been really invaluable information. And for those of you who are participating on today's webinar, I do want to remind you, we will be sharing the recording from this webinar as well as the PowerPoint that Kelly has been referring to throughout. We will also be sharing links to our future webinars. And we have a number of recordings already on our website, including, there were a number of questions today on, as Kelly mentioned, the EB2 national interest waiver, as well as the EB5. And we do have webinars on both of those topics that are certainly worth a watch. So thank you all again for participating. Kelly, thank you. Wishing you all a healthy and safe day. Thank you.
Thank you. Have a nice day.